Hello, YouTube. I'm Vince White. Turning on my light. And I'm an employment attorney. And we're answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. And as I think you can tell by this intro, I do all my videos in one take. We do it live. So we're going to get you the best answers we can. This question was asked, and I'm going to butcher this name, by Enye Kinyeya. I'm sorry. I am positive I got your username wrong. It's the best I could do, and I apologize. I think this question was posted 3 weeks ago on our video we uploaded August 24th of 2022 entitled, I'm not sure I can trust my employment attorney. Should I share my evidence with she or he? And Enye asks, if you were going to hire an attorney for mediation, would you recommend hiring them prior to the employer issuing their position statement or after? Yes. So my take, and this is different than a lot of other firms. There's a lot of firms that would tell you to go do your own EEOC and get your right to sue letter and then call them. That is the stupidest thing I've ever heard, in my opinion. If you hire the attorney to handle the case from the outset, there's a lot that attorney can do to add value and reduce risk all the way through the EEOC process. So if you're going to hire an attorney, the terms are basically going to be the same whether you hire them the day before mediation or at the beginning of the case, generally speaking, right? So hire them at the beginning of the case. Let them know the case. Let them be fully versed in the facts of what you went through. Let them know you. Let them have long conversations with you where they listen to what you actually want, and then they work backwards, creating a plan how to achieve what you actually want, right? If you hire an attorney the day before mediation, they're going to go to that mediation and be like, going to get you money. They're not going to have had that conversation with you. Oh, you don't want money? You want a promotion and a return to work and some work from home. Okay, that you want them to honor your intermittent FMLA and you need to be safe from your person who's been targeting you. Okay, that's good. Can we also get you money? Okay, that's okay too? Okay, great. Like those conversations have to happen, and that's not all, right? Like they go to mediation and they've only glanced at some documents because you hired them right before mediation. They're not really going to understand the risks inherent to your case or the strengths, right? So the quality of advice you're going to receive will be non-ideal, right? I've had cases I thought I was sitting on millions-dollar gold mines, right? And then you litigate the case for a while and you find a couple of things in the case and you're like, oh dear, lots of risk here. Lots of risk. Still a good case. Still think I can win, but don't know if we want to try this case. We got problems, right? And that's a really important thing for your attorney to know and to discuss with you. Because maybe you can say, well, I hear you think that's a problem, but what about X, Y, and Z? Or you might say, yeah, I see how it's a big problem. Maybe we should get this settled, right? So hire your attorney as early as you possibly can. Let them handle the initial filings for you. Let them earn their keep. You're going to be paying them a lot in terms of the back end, in terms of what they win for you, a percentage of that, right? So let them work for it. It's the least we could do. Just kind of as a follow-up here, well, I'll do it as a separate question. Like and subscribe. It helps me to help more people just like you.